We have informed the Court that we do not wish to pursue an appeal against the judgment. This avoids continuing uncertainty for those affected. We're working to implement the judgment as swiftly as possible and will provide a further update in due course.
My Lords, it is nearly 3 months since the High Court found that the government's interpretation of the withdrawal agreement was wrong in law in the way it constructed the EU settlement scheme for EEA citizens to get a permanent residence right. I would suggest that the government needs to undertake some consultations with parties and groups with relevant expertise, and that would include groups like the 3 Million as well as the Independent Monitoring Authority, to ensure that any changes now uphold rather than undermine, as in the past, the rights under the withdrawal agreement. Is the government doing such a consultation, and could he clarify what "in due course" really means?
I can confirm that work is proceeding to implement the judgment. As the noble lady will have noticed from the judgment of the High Court at paragraphs 188 and 191, the Court accepted that before and after the conclusion of the withdrawal agreement, officials in the European Commission understood and accepted the UK's intention was to require pre-settled status holders to apply again for settled status. And in the Court's view, this was embarrassing for the Commission, but did not alter the fact, as was now contended by the Commission, that the text of the withdrawal agreement did not require such a further application for pre-settled status. Therefore, the Court found as it did. The government will certainly implement the findings of the Court. I would add that the EU settlement scheme has been a great success, with over 7 million applications received and 6.9 million applications concluded as of the 31st of December 2022.
My Lords, the High Court judgment was very much in line with the recommendations and spirits of the multiple reports of the European Union Committee and the European Affairs Committee on Citizens' Rights. In the reset of the scheme, will the government make provision for another of our strong recommendations, multiply in these many reports, for the option of physical proof of status?
As the Noble Earl rightly observes, the High Court judgment upheld both limbs of the IMA challenge. Firstly, that the withdrawal agreement residence right of a holder of pre-settled status does not expire for failure to make a second application to the EUSS. And secondly, that a pre-settled status holder acquires the right of permanent residence under the withdrawal agreement automatically once the conditions for it are met. The intention has always been to provide digital proof of status, and that remains the Department's view.
The Noble Lord the Minister give an absolute undertaking that the remedial action which he has referred to in his reply to the Noble Lady Baroness Ludford will be completed and in force by the date which the one that was struck down would have come into this autumn? Will he give an absolute undertaking that that will be remedied by then? And would he recognise that it might be more sensible if the government paid a little bit more attention to the IMA, which was actually set up to give advice on how the withdrawal agreement should be enforced, rather than forcing them to take them to court?
I can certainly confirm that it's our intention to abide by the judgment, and certainly we work very closely with the IMA and will continue to do so.